Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Recently, the Attorney General for Ontario announced that they had sought and received an order freezing the fundraising accounts on GiveSendGo relating to the trucking protest. So a lot of people emailed me and said, hey, what is the law around this? So let's have a look at the criminal code sections and see what they do and talk a little bit about the implications of this. So the criminal code sections here are 490 sub 8, application for restraint order. The Attorney General may make application in accordance with this section for restraint order under this section in respect of any offense-related property. So people say, okay, offense-related property, that's probably a big limitation on this. Well, not that big. Let's have a look at the definition of offense-related property. So that means any property within or outside Canada. This purports to have extraterritorial jurisdiction, although when you start looking into enforcing orders outside of Canada, things get complicated and probably outside of my wheelhouse. So I'll just note that it can be complicated. And that is by means or in respect of which an indictable offense under this act, that being the criminal code, or the Corruption of Foreign Public Officials Act is committed. And B, that is used in any manner in connection with the commission of such an offense, or C, that is intended to be used for committing such an offense. So this is really broad when you think about it, because most offenses in the criminal code are either indictable or hybrid offenses. And what hybrid offenses means is that the Crown can choose whether they want to proceed summarily or by indictment. And for the purposes of this section, it will be treated as if they've chosen to proceed by indictment. So this is basically most of the criminal code. And for my American viewers who are not as familiar with the sort of Canadian legal system, summary conviction offenses are sort of the less serious ones. They have limitations on the degree of punishment. Indictable offenses are more serious. But most of the criminal code is actually phrased in a way where the Crown gets to pick which way they want to go. They can decide that it's going to be summary conviction and limit the potential punishment, or they can decide that it's going to be proceeded with by indictment because they might want a greater punishment. So this is almost the entire criminal code. There are very few sections that are only summary conviction offenses. And we see that is used in any manner in connection with the commission of an offense. That's very broad. Or C, that is intended to be used for committing such an offense. So they don't even need to prove or to show or even to claim that an offense has occurred yet. They can say it's going to happen. Now, let's jump back here and have a look at the, we'll continue on with section 490 sub 8. So, procedure. An application made under subsection 1 for restraint order in respect of any offense-related property may be made ex parte. So what does ex parte mean? It means that you make that application without both sides there. Just the Attorney General can go in and make the application and say, court, we haven't told the other side that we're making this application. We're here today to make this. And there is an obligation when you make an ex parte application that you have to present both sides as you know them. You know, you have to, if you know of any information that is contrary to your side, you are supposed to put that before the court. That's an ethical obligation because it's an ex parte application and the court's only hearing from one side and not from both sides. Because normally if you think about a trial, you know, it isn't just that the Crown argues their side. You're there to argue, to contradict them, to present your own evidence. That doesn't happen in an ex parte application. That's why there's that obligation. Now, you're probably saying, why do they allow an ex parte application on this? Well, keep in mind the general purpose behind this is for stuff like money laundering or this kind of thing. And so if you think that there's an account out there that contains $1 million that's been connected to, you know, some sort of drug transaction, actually, you know, or tens of millions or hundreds of millions, and you send them a notice saying, hey, by the way, in 2 weeks, we're going to apply to freeze this bank account that you've been using to launder drug money. Well, the first thing that they would do is move all of that money into a different bank account, and that kind of defeats the purpose. So that's the reason for the ex parte application here. And I'm just explaining the background of the law. I'm not, making comment here. I'll save the comment on the law until a little later. They say, and shall be made in writing to a judge. So that's a mandatory thing. They've got to do it in writing, and be accompanied by an affidavit sworn on the information and belief of the Attorney General or any other person deposing to the following matters. So it needs to include an affidavit. Now, I don't have that affidavit. I've been trying to get a hold of it. I'm going to keep trying to get a hold of it, and also the order that was granted, but right now I don't have those things. I can't comment on this specific order and whether it was justified under what they swore, because I don't have that information. So I know there's some people who are going to be disappointed with that, but I don't have the information. And I just, I don't want to make stuff up to tell you guys. So A, the indictable offense to which the offense-related property relates. And I suspect that they're going to be arguing mischief here, but I don't know for certain. B, the person who is believed to be in possession of the offense-related property. And C, a description of the offense-related property. Makes sense. They got to say, hey, this is what we're actually asking you to freeze. So restraint order. Where an application for a restraint order is made to a judge under subsection 1, the judge may, if satisfied that there are reasonable grounds to believe that the property is offense-related property, make a restraint order prohibiting any person from disposing of or otherwise dealing with any interest in the offense-related property specified in the order, otherwise than in the manner that may be specified in the order. So there's a lot of kind of legal language here. So first, the judge has to be satisfied that there's reasonable grounds to believe that the property is offense-related property, but reasonable grounds is not proof beyond a reasonable doubt. It is sort of a non-frivolous belief. It's got to be grounded in evidence. It's got to be in some way, reasonable and rational, but it doesn't have to be the only conclusion. So it's perhaps a laxer standard than some people would like, but it's more than than say reasonable suspicion. There has to be some real basis for believing this, but these orders on reasonable grounds tend to be granted fairly easily. The simple fact that you have a police officer or the Attorney General swearing an affidavit saying that there are reasonable grounds is probably going to be enough to convince a judge. Because why would they swear that in an affidavit if it wasn't the case? So when they say disposing of is broader. Most people, when you think of disposing of property, like if I dispose of a car, they think about this in terms of, say, taking it to the dump and having it crushed into a cube, or, sold for scrap or something like that, getting rid of. But disposing of is going to be broader in that sense. It's going to include selling it. It's going to include trading it. If you're restricted from disposing of the money in a bank account, that would include making a withdrawal from that bank account. Or otherwise dealing with any interest in. That's going to be even broader. It would include things like taking out loans on that money and so forth. So this is a very broad, potentially, restriction. They say a restraint order may be issued under this section in respect of property situated outside Canada, with any modifications that the circumstances require. So again, this purports to be able to affect things outside of Canada, but that is a complicated issue that I imagine Give Send Go has their own legal team, and they're probably looking at this. So conditions: a restraint order made by a judge under this section may be subject to any reasonable conditions that the judge sees fit. So this is a clause that allows the judge to tailor this. I'll be interested to see if there's any conditions that have been applied to this order in terms of these fundraising accounts, because there's all sorts of possibilities there. One that I wonder about is if they've created a carve-out, for instance, for legal representation, because typically when protesters are fundraising, one of the things that they might want to, or might be considering, is the need for legal battles. And that's, I wonder if that was included as a carve-out there under the conditions or not. Again, I'm trying to get those orders, and we'll see what happens when they come in. So order in writing, a restraint order made under this section shall be made in writing. It must be in writing, which means it can't be just delivered orally. There's got to be a written form of order for that. This is not a huge deal, but because normally you'd get a transcript if it was made orally, but yeah. Service of order. A copy of a restraint order made under this section shall, again, shall is must, be served on the person to whom the order is addressed in any manner that the judge making the order directs, or in accordance with the rules of the court. So the service in this case would be, I think, on Give, Send, Go. So, and they'll probably just, Give, Send, Go probably has an email address for, or some other means to receive legal communication. And the judge would have included in the order something about how that service could be accomplished. And registration of order, a copy of a restraint order made under this section shall be registered against any property in accordance with the law of the province in which the property is situated. So if they made such an order, for instance, on your house, they would register this order against that in the in the databases, similarly, or in a similar fashion to how they would register, say, a lien on the house or other sort of restriction. So order continues in force. It remains in effect until an order is made under subsection 490 sub 9 or 11, 490 sub 4 or 3, 494. And you're probably wondering, what are all of these things? These are different ways that that orders can be made to either strike this restraint order and say that it's got to be tossed, or there's also provisions for order of forfeiture of the property under section 490 or 490 sub 1 or 490 sub 2. There are provisions for forfeiture of offense-related property. So I imagine that the government is going to be asking for forfeiture of the property, i.e. we want all this money. There's millions of dollars at stake. The government's not going to, they're not going to be like, yeah, we don't care. They're going to want the money. And, or Give, Send, Go, I imagine, is probably going to be fighting this to say, hey, we want to release the money, especially because if you are a fundraising organization and, the whole point of people giving you money is that they want to see that money go to its eventual, to the recipient, then they have a strong interest in fighting to see that happens because, they've made certain promises, and ultimately a fundraising company that doesn't do what they're promising to do is probably not going to be super successful going forward. So offense, any person on whom a restraint order is made under this section is served in accordance with this section and who, while the order is in force, acts in contravention of or fails to comply with the order is guilty of, and we see here this is this hybrid language where you can, they can proceed by indictment or by summary conviction. So first, an offense, an indictable offense and liable to imprisonment for a term of not more than 5 years, or an offense punishable on summary conviction. And again, this is at the Crown's option. The Crown are who gets to decide whether they want to proceed by indictment with a maximum of 5 years or on summary conviction. Now, I'll note here as well that there is no mandatory minimum on this, so the punishment is likely to be less than 5 years. But the big thing, the offense aspect isn't the hugest aspect. It's that they basically claim we now have locked this money down, and the government is now claiming this is a preliminary step to possibly proceeding to try to forfeit this money, to say, we're the government, we're going to keep this. Now, I did some research on this, and, this is not something that comes up all that often, but the offense-related property is really broad. One of the examples is from a case, the Queen and Track, and in that case, they found that bank accounts, for instance, could be viewed as offense-related property, notwithstanding the fact that they couldn't show that any of the money in that account was currently or was actually money connected to a criminal offense, but simply because that account had been used in such a fashion, they could go after the whole bank account. And, again, they couldn't show necessarily that any single dollar in that account was connected to crime, but they just said, well, this bank account has been used, so we're going to seize it. So this is a very broad section. It's not used that often. It's normally used for, again, money laundering, big drug trafficking transactions, You can see as well that it specifically mentions the corruption of foreign officials aspect. So this is, possibly for bribes used against other governments, that kind of thing. So that's what it's really aimed at. I couldn't find a single case where it had been used against a protest before. And that's no matter, what you think of the protest. Protests sometimes get violent. They sometimes get, riotous, these kinds of things. I had never actually seen this used in this fashion before. Now, that's probably partially because we haven't really seen the rise of this kind of online crowdfunding used in protests in the same way that it is being used now. But this probably won't be the last time. If you think back to the 2020 railway blockades, well, if that were to occur again, we might see this tactic used on those, now that this door has been sort of opened and explored. And so this is something that I will expect we'll see in future. The other thing I'll note here is that this isn't limited to going after bank accounts or similar things. In theory, they could go after other pieces of property, for instance, trucks. Now, it's much more difficult for them to proceed in this fashion against the truck, because if you've got a giant bank account, they can just say, listen, we've got reasonable grounds to believe that some of this money is going to be used for some sort of criminal activity, and it's much more sort of spread out, and therefore it's easier to kind of establish that. Whereas for a truck, it's going to be more difficult to say this particular truck is offense-related property and it's being used or is intended to be used in some sort of criminal fashion. The other thing is just number of applications, because it takes a fair bit of work to do this, right? It does take some effort. You're going to have lawyers sitting around, working on this and drafting up the application and going to argue it. It's way easier for them to do this once in a, association with a several $million bank account than it is to go after each smaller piece of property that's been brought by a whole bunch of different protesters. So that's kind of a logistical issue that is also associated with this. And quite frankly, at the end of the day, when you think about the government wanting to seize things, they'd really like to have millions of dollars of cash money. That's really easy and convenient to deal with. Having a whole bunch of vehicles is perhaps a little less sort of tempting in that regard. So those are just some considerations here. Anyway, thank you for watching. Hopefully this has been a little bit at least educational into the functions of this law and how it works. Now, again, I can't comment on the specifics of this particular issuance here because I don't have those documents at this point. I'm trying to get them. I'm working on trying to do that, but that's going to take a little bit of time. Anyway, thank you for watching. Please like this video, share it with your friends, subscribe to see more content. You can also find me on Locals, so there's another way to check these videos out if you want to see them on a different platform. I also want to thank my Patreon supporters at the $50 level: Jonathan Wheeler, Canada's National Farms Association, Mike, Kyle Martin, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited and Marc Olivier Demour. And at the $20 level, Peter Hilger, Mark Whittington, Jane Babin Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Aaron Delso. Thank you as well to all of the $10 supporters who will be in the crawl immediately following. Yeah, this is a complicated scenario, and as I said, this opens some doors to different tactics used to, crack down on protests in future. This is law that was sort of aimed at dealing with money laundering and, bribing foreign governments and that kind of thing. But the application of it is potentially very broad in terms of what they could go after. So anyway, hopefully you guys understand this section a little bit better. And if you have questions, leave them in the comments below. As I said, still trying to get a hold of the actual affidavit that was sworn on this one. So I'll have some more comments once I'm able to get that, assuming I'm able to get that. Anyway, thank you for watching. Hope I've armed you with knowledge.